Brings us to number 10, matter of Level 3 Communications, LLC versus DeBellis. You may proceed.
Thank you, Your Honor. Good morning, Your Honors. Dean Yuzek for the appellant. May it please the Court. This Court, under similar circumstances in the Coliseum Towers case, and Your Honor, under different circumstances in the Brody case, addressed the issue of timeliness in the context of an Article 5 case. And the key is that when the Westchester County Director made his report and recommendation to the city on appellant's 556 applications, the tax levying bodies had a statutory duty. That statutory duty is at RPTL section 556.5, which explicitly provides that the tax levying bodies are required to act on the county director's recommendation and give notice to the applicant, here level 3, of the rejection or approval of the 556 application. And if Your Honors look at page 190 of the record, the county director reminded the local assessor by letter on December 22, 2006, with a copy to the Mount Vernon City Council of the obligation to, quote, make sure the applicant is notified of the final decision of each applicable tax levying body for these applications and any previous applications where a final decision has yet to be mailed. Now, this Court made clear in the Coliseum Towers case that the 4-month limitations period does not begin to run until there is an affirmative refusal to act and is not triggered by mere or even prolonged inaction. And this Court also found in that case, involving RPTL Article 5, that there was no merit to respondent's contention there. The same contention by respondents here, that the applicable 4-month period began to run when the assessment roll became final. That cannot be the trigger where the public body has a duty to act enjoined upon it by statute as here. And the nearest indication of action following Level 3's Article 5 applications and the county director's reports and recommendations to the local assessor in the city was in early January 2007 when Level 3 received its next tax bill, the very first one that it received after making its Article 5 applications, which reflected that the local assessor in the city were either ignoring or had been denied the county director's recommendation without having given Level 3 notice as required by RPTL 556.5. Level 3 timely filed its Article 78 proceeding later that month. And while Coliseum Towers was an Article 5 case, Judge Dickerson, your Brody case, as Your Honor clearly explained, was not. The issue in Brody was not a governmental official's failure to act in relation to a Section 556 application involving an unlawful entry, but an official's alleged refusal to send the petitioners a star exemption form, which, even accepting the allegations of petitioners there as true, could not possibly have been an unlawful entry, clerical error, or error in essential fact, as those terms are used in Article 5, as Your Honor explained.
Counsel, let me interrupt you for a moment. You just made reference to unlawful entry.
Yes,
and I'd like to ask you a few questions about that. Of course, this is an Article 5 petition that was made, and it's seeking a refund based on an unlawful entry. Unlawful entry is defined under Section 550, Subdivision 7E of the Real Property Tax Law. Unlawful entry states an entry of assessed valuation of a special franchise on an assessment roll or tax roll which exceeds the final assessment thereof as determined by the State Board. My question to you is regarding special franchise on an assessment. Does your client fit into that category, a special franchise, when there wasn't any type of special franchise agreement between your client and the city of Mount Vernon.
Yes, Your Honor, and I think the best way to explain that, permit me to take Your Honor first to the ordinance in the Mount Vernon City Code addressing telecommunications franchising. That ordinance was adopted and approved by the City Council in late October 2000, more than 15 months after Level 3 received the permit in early July 1999 to place its property under the city's streets, as shown at pages 312 to 314 of the record. The ordinance on which respondents rely, which states Section 239-3 that permits for the installation of telecommunications equipment shall not be issued prior to the granting of a franchise or a revocable license, could not have applied to Level 3, which obtained its permit and was in the ground long before the ordinance became effective. And the definition of special franchise, Your Honor, talks about not just a franchise, but permission, authorization.
Well, the permit you refer to is the street opening permit, is that correct?
It is, Your Honor.
And they had nothing beyond that, is that correct?
It's the street opening permit which clearly showed what was going into the ground, and based on well-settled case law addressed starting at page 22 of Level 3's principal brief and at page 10 of our reply brief, the fact that Level 3 is obviously in Mount Vernon, at least under color of governmental authority or consent, renders its property taxable as special franchise property. And moreover, the ordinance, the city ordinance provides at Section 239-14 that to the extent permitted by law, the city may determine to apply all or certain provisions of this ordinance to telecommunications providers existing on the effective date of this ordinance. Level 3 has never been given notice by the city of its election to apply the ordinance to it, or whether the city has determined to apply all or only certain provisions of the ordinance to Level 3, or on what authority it purports retroactively to apply it. And the other significant legal issue, to answer Your Honor's question, is that the Court of Appeals explained in the 1978 City of Mount Vernon case against the State Board that a local tax assessor's dispute over the State Board's tentative special franchise assessment must be resolved before a final assessment is made by the Board. If the City of Mount Vernon did not agree with the notices of tentative special franchise assessments it received from the State Board, one example of which is at page 217 of the record, including the State Board's characterization of Level 3's property as special franchise property, the city had an opportunity to complain under RPTL Section 610 and attend a Section 612 hearing, the date, time, and place of which
When
was on the State Board's notice.
When was the first notice from the state to the city of Mount Vernon? What was the date of that?
The first notice would have
the
been
notice that they could have challenged.
2003, 2004, 2005, 2006. Those notices, Your Honor,
So the city
are
could
in the
have-
record.
Your position is the city could have taken made an objection at that point.
Absolutely. And indeed, Your Honor will also see a complaint form, RP 7142 at page 322 of the record. Near the bottom, on page 323 under Part 2, grounds for complaint. The city simply could have checked the box for letter C, number 1, which states, and I quote, "Tangible property included in value is not special franchise property," close quote. As the Court of Appeals also made clear in that Mount Vernon case, if the city ignores the opportunity to complain and be heard, as was the case here, and the State Board's assessment then becomes final, the final assessment must be treated as if the local assessor had made it himself. Under RPTL Section 616, it was the local assessor's ministerial duty to enter the State Board's final assessment on the assessment roll. He did not have the discretion to substitute his judgment. And Judge Dickerson, I need to come back to the payment under protest issue.
This will have to be
because
your last point. Go ahead.
I recognize it's important. In the Mercury Machine case, the Court of Appeals explained that there is an exception to the requirement that taxes be paid under protest where there is a statutory procedure for the recovery of such taxes. Here, RPTL Article 5 is such a statutory procedure. And as stated at Section 5562A, whenever it appears to a taxpayer that it has paid a tax attributable to an unlawful entry, then such taxpayer may apply for a refund so long as the application is made within the 3-year limitations period of 5.
But while you were paying erroneously, or were you paying under protest, at least in your mind, so to speak? That's what I want to understand, your position regarding that.
Your Honor, I can't fairly answer that as a matter of record. I can only tell Your Honor that I believe that the people at Level 3 did not believe, given this legislation, that they were required to make that protest. Would it have been better if they had? Yes, because I wouldn't be here talking about it today. But the language of 556-2A would not make sense if a contemporaneous protest were required. And any dicta in the Third Department's community health plan case to the contrary is, I respectfully submit, incorrect. And finally, the opinion of counsel for the State's Office of Real Property Services, Volume 6, Number 9, under the last colored tab of appellant's brief, confirms that since the restructuring of the correction of errors laws in 1974, there is no longer a requirement that a payment be made under protest if the error is of the type defined in RPTL Section 550, which includes unlawful entries. Thank you, Your Honor.
Thank you, Mr. Yuzek.